Yes.
Judge, I have a question about the finality of this morning's decision. Considering how long this may take, hypothetically speaking, if there were a change in administration in 3 years, acknowledging that double jeopardy attaches probably when the jury is impaneled, is there a way that this decision might not be final, that these cases could be sent back to a military court?
Well, there are two complications with this morning. As I heard reference to, although I've not seen myself, I'm simply reporting, this is straight hearsay, that there is in fact a statute that requires notification of Congress 45 days before folks like this are brought over so that they can do something in response. I don't know whether that's the case. If it is, and whether they're going to do anything in response, I don't know. But the question of the government's, not the government's, but the question of what rights aliens have when in custody of the U.S. government is one that is at the least unsettled under the law. But the degree of contact between the alien and the United States has a whole lot to do with it. That's why there was such an effort made to keep out those who were coming in after the Mariel, the release of prisoners from Mariel took place because once they set foot on American shores, they have rights that they did not have before. If these people are brought here, notwithstanding that they're brought here against their will, the likelihood of it being very easy to send them then back to another area that is remote, secure, and humane, it seems to me is open to question. So it ain't going to be that easy. Yes?
General, what do you make of the critique that some enemy combatants held in Guantanamo are not actually enemies of the United States, but maybe enemies of factional interests in Afghanistan, that some warlords in Afghanistan are simply picking up their factional enemies and declaring them enemy combatants to the United States?
Nobody is in favor of holding people who were simply picked up and turned over on the basis of somebody settling a score. And I favored, before I went to Washington, and I favored after I got to Washington, a robust procedure for separating out people who didn't belong there from people who did. That said, if people have trained in a terrorist training camp, as the people, virtually all of the people at Guantanamo have, I don't know that they're subject to quite that objection. Yes?
Judge Mukasey, your comments on the Speedy Trial Act give rise to a concern that has been expressed by many that in trying these particular people in Article III courts, we may actually, in order to get convictions, compromise the law that we have for ordinary criminal proceedings. Would you care to comment on that? Yes,
that's a real concern, and it applies not only to the Speedy Trial Act, but also to rules of evidence and to a whole lot of other protections. There is a certain hydraulic pressure that's applied in cases like this that tends at times to distort rules when when the stakes are very high. And if those pressures are brought to bear here, the law that's created is going to be a law that's applicable straight across the board in all criminal cases, and it could do a whole lot of damage. In other words, once the rules are created here, it's nearly impossible to confine them solely to terrorist cases, whereas obviously to the contrary, that's not true in military commissions.
General, is it true that if something less than capital murder charges are brought, or they plead to a lesser charge, and these defendants serve a number of years, that when they're released, if they can't be deported, they could be released into this country? Well,
I suppose it's conceivable that they could be deported. It's also conceivable that they could not. And I wouldn't want to gamble on that. Secondly, to the extent that they are within the prisons, they are a threat there as well. Each of these people would be virtually a totemic figure in a prison. And I've heard it suggested that, well, we can keep them in solitary confinement and not allow them to be exposed to the other prisoners. Mr. Reed, who is serving, remember the shoe bomber? He's out in Florence, Colorado. He was in solitary confinement and challenged what are called the special administrative measures that had him in solitary confinement. The administration chose not to contest that, and so he's now free as he wanted to worship and to meet with his fellow prisoners, as others may very well be, if they are similarly confined.
Thank you, Judge, and I must say that he has again shown his great service to America, even though he no longer has an official position, by expressing these views so that all can hear him, and hopefully people will follow them. We owe him a great debt, and let's give him a great round of applause.